Thank you. All right, Mr. Oliver, just a moment. Must be coming in person. You're done in front of Judge Olsen.
Yeah, they're done. Oh, I'm sorry.
I was talking to my phone.
Oh, okay, I'm sorry.
Here we go. Thank you for coming early.
Oh, no problem at all.
All right, this is in the matter of the people of the state of Michigan versus Castro Oliver's. We have two files, 24-21891FH. And I'm sorry, you guys can talk. I'm sorry, I didn't realize you needed to talk. I apologize.
Yeah. Just, can we just have 1 second?
Yeah, you guys take your time.
Thanks.
I'm not going anywhere.
That's no way. So.
You ready?
Yeah.
Okay, so this is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891FH and 24-21892FC. I have David McCready appearing on behalf of the people and Michael Dagger Margosian appearing on behalf of the defendant. This matter was set for 10:30 this morning for potentially a plea. All the parties were available. Mr. McCready was kind enough to come down early today. So Mr. Dagger Margosian, are you ready to proceed?
Yes, Your Honor.
And Mr. Dagger Margosian, how would you like to proceed today?
Your Honor, there is a plea offer, and it is our intention that Mr. Oliveras will be pleading guilty.
Can you speak up just a little
It's
bit?
our intention that Mr. Oliveras will be pleading no contest on the 9-2 FC case and guilty on the 9-1 FH case.
So on 24-21891FH, I have received an amended felony information. So Mr. Dagger Margosian, which counts will he be pleading on that file?
Your Honor, on the 9-1 FH case, Mr. Oliveras will be pleading guilty to, I guess it would be an added count of home invasion second. And
Yep, that was added as count 3.
correct.
Okay,
And the original 2 charges, counts 1 and 2, and the original information would be dismissed,
as well as the habitual
As
offender
well as-
information.
as well as the habitual on both files, yes.
Okay, and then on file number 24-21892FC, he has count 1 assault with intent to murder and count 2 is a habitual offender second offense notice.
Your Honor, on that case, Mr. Oliveras will be pleading no contest to count 1 there, and I guess additionally, there is a sentencing agreement on both of the cases as well.
Okay, and what is the sentencing agreement?
Sentencing agreement is that Mr. Oliveras would serve an MDOC sentence of 6 years to 15 years concurrent on both matters.
All right, and Mr. McCready, is that a correct recitation of the plea?
That is correct. I would indicate that the plea agreement that we submitted to the court does indicate that he'd be pleading guilty on both cases. But counsel and I have had a discussion this morning, and we're agreeing to that it's okay for him to plead no contest no contest on the AWIN case.
Okay, all right, so, and the purpose of the no contest plea, lack of memory or civil liability?
Civil liability, yeah.
Okay, very good.
Lastly, I guess this would obviously apply anyway, but Mr. Oliveras will be getting credit for the time served that he's been in custody pre-trial.
He's not on parole.
No.
Okay, then he would get.
Yeah, I just wanted to put that on record.
Okay, so Mr. Oliveras, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Oliveras. Can you state your full name for the record, please?
Castro Cash Oliveras.
Now, Mr. Oliveras, you've heard the discussion we've placed on the record, and you've heard the statement of your attorney and the prosecuting attorney. On file number 24-21891FH, I'm sorry, is it your intention to plead guilty to count 3, home invasion, second degree? Miss Adams, we need to send over to the jail the notice of, or his advice of rights form to be signed. Miss Adams, are you in your office?
Yes, Judge, yes, okay.
Okay, I'll need them for both files. Thank you. All right, so Mr. Oliveras, we've had some changes in the law. And so even though we verbalize the entire advice of rights form, it is now requested that we have you sign an advice of rights form. So they're going to make their way to you to sign, and but in the interim, we're going to go through your advice of rights. So okay. And we need to print this off because I haven't yet. Okay, so, Mr. Oliveras, is it your intention on file number 24-21891FH to plead guilty to count 3 home invasion second degree, which carries a maximum penalty of up to 15 years in prison? I'm sorry. And or a $3,000 fine. So is it your intention to plead guilty to that count?
Yes, ma'am.
And you understand count 1, count 2, as well as the habitual offender second offense notice will be dismissed at the time of sentencing. Do you understand that?
Yes, ma'am, I do.
All right. And then Mr. Oliveras, on file number 24-21892FC, is it your intention to plead no contest to count 1, assault with intent to murder?
Yes, ma'am.
And then the habitual offender notice on that file will also be dismissed. Is that correct?
Yes, ma'am.
Now you understand that there's been a Killebrew agreement between the prosecutor and your attorney that the prison term that you serve will be 6 years to 15 years with Michigan Department of Corrections, and that those sentences will run concurrent and you will receive credit for any time you've served already. Do you
Yes,
understand
ma'am, I
that?
understand. Yes, ma'am, I do.
Okay, good. Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, I'm satisfied.
Okay, now you understand assault with intent to murder carries a life or any other number of years as a sentence, but the attorneys have agreed that your sentence will be 6 years. Do you understand that?
Yes, I do.
All right. So other than that agreement that was placed on the record, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. McCready?
Correct.
Mr. Dagger Margosian?
Your Honor, the only thing I'll add is on the AWIN, as it is a life offense, obviously the court would have to establish a statutory, a maximum amount of that. And so if the court is in line with it as well, we've determined that the maximum amount would be 15 to line up with the home invasion second.
Right.
Okay.
Yep, I think we placed that. I think we're good on that. Thank you. All right. And would you agree with that as well, Mr. Oliveras?
Yes, ma'am.
All right, so Mr. Oliveras, if a guilty plea and a no contest plea are accepted, there will be no trial. I'm so sorry. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. I'm so sorry, my allergies are killing me and I can't breathe. So, however, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Oliveras?
Yes, ma'am, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Do you understand that?
Yes, ma'am.
Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Oliveris?
No, ma'am.
All right, so we're going to start with file number 24-21891FH. And Mr. Oliveris, this is the file that your attorney stated it's your intention to plead guilty to count 3 home invasion 2nd degree. So how do you wish to plead to the charge that on or about December 31 of 2023 in the city of Adrian in the county of Lenawee that you did commit the offense of home invasion 2nd degree? Guilty or not guilty?
Guilty.
All right, so now we're going to move on to file number 24-21892FC. And this is the file that your attorney has indicated that it's your intention to plead no contest to. So, Mr. Oliveris, how do you wish to plead to the charge that on or about June 2nd of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense of assault with intent to murder? So your options are no contest or not guilty. How do you plead to that charge?
No contest.
All right. Other than the agreements that were placed on the record, has anybody made any threats or promises to you to induce you to plead guilty and no contest to these charges?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargains to induce the defendant to plead guilty and no contest? Mr. McCready
No, Your Honor.
and Mr. Dagger Margosian?
Okay.
All right, so Mr. Oliveris, there's a comprehensive agreement that was placed on the record, but has your attorney promised you anything outside of that to induce you to plead?
No, ma'am.
And it's your own choice to plead no contest and guilty, is that correct?
Yes, ma'am.
All right, so we're gonna start, and I'll let you do the factual basis on the FC file, but we're gonna start with file number 24-21891FH. So Mr. Oliveris, this is the file that you pled guilty on. So on December 31st of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, I was.
All right, and then did you enter a dwelling located at 1221 South Main Street, apartment 44?
Yes, I did.
All right, and did you enter that dwelling without permission?
Yes, I did.
And then when you entered or exited that, did you commit an assault on an individual?
Yes, I did.
Okay,
People are satisfied.
all right. With regard to this file, has the court complied with MCR 6.302 B, C, and D? Mr. McCready
Yes.
and Mr. Dagger Margosian,
Yes, Your Honor.
is there an issue?
I don't know if the court needs to establish who the person is.
Would that individual you assaulted be Troy Pasha?
Yes,
It was-
yes, it was.
It would, on that particular case, Your Honor, it would be one.
Oh, I'm sorry, wrong person. How about Juan Sanchez?
Yes, yes, that's him.
Okay, we'll go with Juan Sanchez. All right, so now we're on that file. Are you satisfied now?
Yes, thank you.
All right, I'm sorry. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. So we're going to move on to file number 24-21892FC. This file, he pled no contest. So Mr. McCready, if you could place the factual basis on the record for me.
Yes, sure. I'm going to read from the report of Officer Rose Nito, now Rose Young. This is page 11 of 23, and I will provide the court with a hard copy of this. But this regards location of 1221 South Main, apartment 35 in the city of Adrian, county of Lenawee. And a person by the name of Troy Pasha. So reading from the report, Troy then walked to the front door of the apartment and began knocking. Troy advised he could hear Castro walking inside the apartment. Troy walked back to the patio window and began knocking again. Troy observed Castro walking down the stairs carrying his daughter. Troy advised Castro open the patio door while holding his daughter, but Troy did not want to confront Castro while his daughter was present. Troy advised Castro to quit hitting his sister and for him to leave her apartment. Troy stated Castro stabbed him with a kitchen knife in the neck, then his arm. Troy advised the blade of the knife was stuck in his arm and he had to pull it out. Troy advised he threw the blade near the patio, then began walking to his sister and niece's apartment for help. That's the end of the relevant portion of the report. I do believe that the parties will also stipulate that the stabbing, especially regarding the stabbing in the neck, was done with the intent to kill Troy Pasha.
Correct, Your Honor.
All right, so Mr. Oliveris was holding a child?
Correct.
Okay. All right, so based on the facts placed on the record and from the information contained in the police report that was referenced by Mr. McCready, the court finds beyond a reasonable doubt that on June 2nd of 2024 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of assault with intent to murder by stabbing Troy Pasha multiple times, most seriously being him being stabbed in the neck, which would indicate an intent to commit the crime of murder, and therefore the court accepts the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. McCready and Mr. Dagger-Margosia.
Yes, Your Honor.
Yes.
All right, I accept, as I said, the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, other than the Killebrew plea that was placed on the record regarding an MDOC prison term. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Dagger-Margosian, are you available on June 27 at 8:15?
Yeah, yes, Your Honor.
All right, Mr.
Sorry,
McCready.
people, yes.
All right, and is there any request for in person or via Zoom by the people?
Either way is fine.
All right, Mr. Oliveris, you have the right to be present in person for sentencing, or you can waive that and appear via Zoom. How would you like to appear for sentencing?
I would like to appear in person.
Okay, so I will set this for sentencing on June 27 at 8:15 in the morning, and that will be in person. So we will make sure that you're brought over. Mr. Oliveris, someone from the probation department will come over to the jail and meet with you. Obviously, you do not need to make a statement about the file that you pled no contest to, all right? With regard to the file that you pled guilty to, I would ask that if you do make a statement, you be truthful about the offense and your background. They'll prepare a pre-sentence report. We'll provide a copy to your attorney. Mr. Dagger-Margosian always is very prepared and will review that with you in advance. And then we'll see you back here in person on June 27 at 8:15. So thank you, Mr. Oliveris.
Thank you.
You're all set. Thank you.
All right.
All right, so I have, hold on, Mr. Dagger-Margosian, in the matter of the people of the state of Michigan versus Jasmine Elizabeth Sarabia, file number 25-22249FH. Thank you. Is there any contact you've received?
Your Honor, I called the phone number I have listed. It is out of service. I think this is the first pre-trial, and I think we have.
It's an arraignment.
Okay, so I guess even with that being said, the last time, I guess I'll just update the court. The last time I spoke with her was when she was in custody. I don't know if she just got confused about the date. I guess I would ask the court
I can adjourn this to May 28th.
I think that's.
If she fails to appear though, I will issue a bench warrant.
Understood.
So I will set rearrangement on May 28th at 8:15. Obviously, if she's not here, I will issue a bench warrant at that time.
Thank you.
All right, thank you. Rhonda Underwood, thank you. I think that's all you had. So Rhonda Underwood, I got everybody here for you. I know you were very busy because I watched you down in Judge Olsavers. So I'm going to call the jail to get your people lined up, and I've got 6 of them in the waiting room, ready to go. Hi, this is Judge Anzalone. I am ready for Israel Vila. I would like him first if I could.
Okay.
Then Angel Rosas, Angelina Hall, and Christina Edmonds, who's down on first floor.
Give me 1 minute to give you. You say Bella first, and who's the second one?
Rosas,
Angel,
Angel, yep,
and then who else?
Angelina Hall.
Okay,
And then down on the first floor, I have Christina Edmonds, so she could be last.
okay, sounds good.
Awesome, thank you.
Okay, okay.
All right, so Ms. Underwood, we're gonna start with Matthew Sinclair. You said, stopped you a little bit and you were down there in front of Judge Olsaver. So this is in the matter of the people of the state of Michigan versus Matthew Richard Sinclair, file number 24-21920FH. This is the date and time set for a violation of probation pretrial. I have Ron Underwood appearing on behalf of Mr. Sinclair. I have,
It's Mike McCarron, Your Honor.
right, I do have a recommendation. I think we sent that to you. How would you like to proceed today with Mr. Sinclair?
Is Mr. Sing, can I just have a brief minute with him, Your Honor?
So, Mr. Sinclair, I am going to open up a breakout room for you and Miss Underwood.
Okay.
Find her. There she is. There you are. All right, go ahead and join that breakout room. I'm going to send a message to all the people in the waiting room. Sent a message to the waiting room that Miss Underwood is with us now, and I will be bringing you in individually, so it should not be much longer. Oh. All right.
Going on, Angelo?
Not much. How you doing?
Man, I'm feeling good, man. I'm feeling good.
Well, that's a good thing. Miss Underwood will be with us in just a moment, okay?
Hey, listen, man, listen, Miss Angelo, I don't want to proceed with her. She's not up to my speed. I got a lawyer. I'm getting my lawyer on Friday finally. I just don't want to proceed with her. She really, this is a bless her soul, but
So hold on. Did you hire an attorney?
listen, Ghostin is not gonna call up here until I make the first payment on Friday. So he's not getting on. So if we could just postpone it one more time or something, because bless her soul, she just can't keep up with my speed, and I got so much shit going on upstairs and downstairs, and she's not keeping up with me. I can't. Bless her soul though, she does her best.
All right. So I'm gonna stop you real quick, and as soon as she gets in, we'll adjourn it on the record, okay?
All right, thank you.
You're welcome. All right, Ms. Underwood, I'm gonna skip real quick to Mr. Vila. In the matter of the people of the state of Michigan versus Israel Vila, file number 25-22210FH. Ms. Underwood is appearing on behalf of Mr. Vila and Ms. Arnold on behalf of the people. Ms. Underwood, Mr. Vila has informed me that he will be retaining David Goldstein, and he is asking for an adjournment. So I am going to adjourn his case out to May 28th at 8:30 in the morning. So Mr. Vila, we'll give you that 2 weeks to retain him, and we'll see you back on May 28th at 8:30 in the morning with Mr. Goldstein, all right?
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
All right, thank you. All right, let me bring Mr. Sinclair back.
Oh, Your Honor, would you like me to do the stip and adjournment
Yes, please.
with Ms. Arnold's permission?
Of course.
Okay, all right, Mr. Sinclair already came back. All right, Ms. Underwood, what I will say is based on the recommendation and the fact that Ms. Sinclair was not requesting jail, I would not be ordering jail if he pleads to the violation.
Well, Your Honor, this is my feeling. Mr. Sinclair is willing to plead guilty to the violation, Your Honor. He meets with District Court Probation for his pre-sentence down there tomorrow. At this point, Mr. Sinclair has paid off his fines and costs. In fact, he did 4 days in jail when he was picked up on this violation in March, Your Honor. I would just ask that it be a plea and discharge, I think, at this point.
I ordered that he do counseling with Sally Welsh, and he's not done it.
No, I've been attending for the last 4 weeks now, and I have it paid up for the next 4 weeks with Sally.
So I'm willing to adjourn this out for him to complete counseling with Sally Welsh, but I'm not willing to terminate his probation until that's completed.
I understand.
So how long is that program with her, Mr. Sinclair?
We're doing a total of 26 weeks. So, and I've met with her. I've met with her 4 times so far. So,
okay.
It's every Thursday at 6 p.m. I meet with her.
All right. So, all right, I can set this out to November 12th at 8:30 in the morning. And if he's completed it, I'd be willing to do that. That should give him his 26th. November 12th at 8:30 in the morning, we do the notice. If he completes it, then obviously I'll be glad. But if he fails to complete it or violates in any other way, obviously that would change that. So Mr. Sinclair, continue reporting to probation, complete your programming with Ms. Welsh, and we'll see you back on November 12th at 8:30 in the morning.
All right. Thank you very much, Your Honor.
All right. Thank you.
Yep.
Okay. What case are you here for? Israel Vila? Oh, we've already, I'm sorry. So are you family members?
Yes.
Okay, he got here early and so did the attorneys. He did plead today and he's set for sentencing on June 27 at 8:15. At 8:15. Okay?
All right.
All right, thank you. If you go on YouTube, you can watch it.
Okay.
Because I have a YouTube channel.
Yeah,
So go ahead and you can watch his plea on that.
I just came from Rural Support. He says, Grandma, you won't be there. I said, yes, I will.
He didn't mention you were coming or I would have waited. I'm sorry.
Did his mom get here? She's coming from Detroit.
No. Or not yet. So you might want to reach out to her.
I'll wait for her.
Okay, thank you.
Thank you.
All right, who do I have from the jail?
Joe Rosas.
All right, Ms. Rosas. Let me get your paperwork. Okay. So this is in the matter of the people of the state of Michigan versus Angel Rosas. File number 25-22142FH. This is the date and time for a couple things. We have a failure to appear for pretrial on March 19 of 2025. And then we also have a complaint for violation of bond conditions, which alleges that Ms. Rosas has violated her bond conditions and that she was not to have contact of any nature with Miguel Rivera, not to be at the victim's residence, no weapons in her possession, and no assaultive behavior. The allegation, Ms. Underwood, is that she violated her bond conditions by being in contact with Miguel Rivera on May 9th of 25 at 5:20. I guess that would be AM, I don't know, or PM at his apartment, and that she committed a felonious assault against him with a knife. So I don't know if those charges are pending. Obviously, they would
Your
be
Honor,
down.
they are.
Yeah.
There's a huge misunderstanding about the knife situation, but
Always
at this
is,
point,
right?
At
Nothing,
this
go ahead.
point, I'm going to ask to adjourn this matter until we see how things go in district court. I think I have
Okay.
to.
Do you know when the next court date is in district
Hang
court?
on. I think it's Friday or Monday.
This Friday? Okay, so what I will do is my next available pretrial is May 28th at 8:30 in the morning. And I will set it over to that. You want to do the stipend order to adjourn?
Thank you, Your Honor.
All right, so May 28th at 8:30 in the morning. And we will see you back on that day. All right, thank you, Ms. Rosas.
Is Mr. C on Zoom, Judge?
Hmm?
Is Mr. C on Zoom?
Yeah, I did.
Okay. Thank you.
Okay, so let's go to the waiting room. All right, Adam 9.
Alrighty.
We're gonna take Adam 9 next. I do not have, oh, there he is. All right, Mr. 9, hold on one second. This is in the matter of the people of the state of Michigan versus Adam Matthew 9, file number 24-22018FH. Mr. 9 is present with his attorney, Ron Underwood, and I have Isaac Sneed appearing on behalf of the people. So, Ms. Underwood, how would you like to proceed today with Mr. 9?
Your Honor,
He's been
first of all,
referred to
thank Mr.
ECU,
9
is
for
that
being very
correct?
patient this morning. Your Honor, Mr. 9 is complying with the civil pay schedule of the restitution in this matter, Your Honor. I'm trying to find a way to negotiate this and agree to an amount. Either, so I would ask for another pretrial in this matter, Your Honor. Mr. 9 is paying according to the accelerated schedule and doing very well, Your Honor.
Did he get, I missed it. He was referred to the ECU, correct?
Yes, but that can only be done if we have an amount, Your Honor. And thus far, we haven't been able to agree on one.
Okay, so I am going to set this out to June
Your Honor,
18th. Oh, I'm sorry, go ahead.
could I address the court, please?
Yes.
At this point, we're asking the matter just be set for a trial, and we're going to withdraw the ECU diversion.
No.
Do you, hold on, everybody stop. Mr. Sneed, do you have an amount of restitution?
We do, and this has been communicated to council repeatedly that the amount of restitution is $68,000. The understanding is that the $50,000 of that amount is subject to the civil judgment is going to be paid according to that schedule, with the remaining $18,000 to be paid through ECU. The total amount in the ECU agreement would be $68,000, and it would reflect all of the terms that I just stated on record regarding the payment. So I don't understand what the confusion is. This has been the offer for months.
So wait a second, everybody stop talking. Now that you said that, it does trigger a memory. This topic came up because he has a civil judgment that was less than the amount of restitution. So that was brought up at the last pretrial. And so we actually did research on that because we weren't clear on it, Mr. Sneed. So this delay is probably at this point my fault. Ms. Underwood, we did do research, and yes, we have to order that restitution is in the full amount. Whether, don't interrupt me. Don't interrupt me. So restitution must be, that was the question, Mr. Sneed, and I actually, Rhonda, don't talk over me. Stop talking. So Mr. Sneed, I will tell you that the last adjournment or so was the fault of the court because the court had never addressed this issue before. And so the people, I don't remember, I think it was Ms. McClure had said, no, the full amount of restitution is due. And Ms. Underwood said, well, there's a civil agreement. And I didn't know the answer to it. So I will tell you, Mr. Sneed, I take full responsibility for the adjournment because I needed to research that issue. And we did determine that the court must order the full amount of restitution, whether or not, under the law, whether or not there was an agreement. So Mr. Sneed, if I can just say that this last adjournment or so has been the faults of the court, could Ms. Underwood have one more conversation with her claimant about ECU?
Well, Your Honor, at this point, we're just asking it be set for trial, and we'll enter into those negotiations prior to the trial date. But I mean, this is like beating your head against the wall for the last 5 months dealing with this issue. So we just like to get something on the calendar at this point. I understand the court schedule packed, but we've gone round and round here. So I'd like to just get a trial date.
It's not fair.
I'm just curious, am I allowed to say anything?
You are, but you're not allowed to talk over me, which is why I asked you to stop talking over me. Now you can speak, Ms. Underwood.
Thank you. Okay. So it's my understanding that the diversion amount would be $68,300, correct?
Mr. Sneed?
That is the restitution amount, correct?
I believe I stated $68,000 earlier.
Okay. Your Honor, can I have 1 second with Mr. Nine? Mr. Nine and I have discussed this.
Okay, so, and I think that Mr. Sneed is not saying they're precluding ECU at this point, that there would be a discussion between you and the prosecutor on this file, but that there was a request just to get a date on the calendar. Mr. Nine, just because I scheduled something for trial doesn't mean it's actually going to trial. It sounds far worse than it is. And I'm not even scheduling trials to August, September. So, you know, I don't know if Mr. Sneed will let him continue on ECU today. Because it sounds like they're taking a position, but they're not barring any other discussion with you, Ms. Underwood.
Your Honor, this is all because she was saying, well, maybe it's 68, maybe it's more. The police report says more.
Okay.
You know what I'm saying? I never.
I understand, Miss Underwood, but Mr. Sneed is not Miss McClure today, so that's probably a discussion you need to have with Miss McClure and.
No,
This is.
Thank you, Your Honor.
So let me just set it, I'm just gonna set it for another pretrial, and I'm gonna set it for June 18, and then at that point, if there's not some kind of resolution, we will,
No, let's
set a trial date. So I'm gonna set it for June 18 at 8:30 in the morning. I'll do the notice of hearing because I'm requesting the pretrial. And, Miss Underwood, you don't have to do this step in order. And then we'll see you back for pretrial on June 18. And in the interim, you can have that discussion with Miss McClure. All right? All right. So we'll see you back on June 18 at 8:30 in the morning. And Miss Adams, if you can do the notice. All right, we're all set, Mr. Nine. Thank you.
Thank you, Your Honor.
All right, Angelina Hall. Let's see.
Yes, ma'am.
Yep, let me grab your file. So this is in the matter of the people of the state of Michigan versus Angelina Ann Hall, file number 25-22152FH. I have Brenda Underwood appearing on behalf of Miss Hall, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a, is it a pretrial? So this is the date time set for pretrial and contempt of court for a failure to appear on April 9 of 24 or 25. So Miss Underwood, how would you like to proceed today?
Your Honor, I've discussed this matter with Ms. Hall and Mr. Bayonetto. And at this time, Your Honor, Ms. Hall is going to plead guilty to resisting and obstructing with no habituals, Your Honor. And also, there's an agreement to no further jail, no further upfront after sentencing, Your Honor, in this matter. And I believe Ms. Hall will also plead guilty to the contempt.
Okay. Is that a correct recitation of the plea, Mr. Sneed?
Yes, thank you.
All right, okay, so Ms. Hall, you want to raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Hall, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, police officer assaulting, resisting, and obstructing, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine? So is it your intention to plead guilty to that?
Yes, ma'am.
And do you understand the habitual offender third offense notice would be dismissed at the time of sentencing, and at the time of sentencing, there would be no further jail? Do you understand that?
Yes, I do.
All right. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
All right. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Is that correct, Mr. Sneed?
Yes, it is, Your Honor. Thank you.
And Ms. Hall, is that correct as far as you're aware?
Yes, ma'am.
All right. So Ms. Hall, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. Ms. Adams, we also need to send a notice of, or what do they call it? Her advice of rights over to the jail to have her sign those. So we're required now to give you a written advice of rights and have you sign it. So they're going to give you that today. You just need to sign it. I'm going to go through them with you anyway, but for some reason they think we need to do that too. So you may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms or conditions on bond, or the terms of any sentencing and plea agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do.
Okay, do you understand that if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you understand that?
Yes, I do.
Do you have any questions about the rights that I've given to you, Ms. Hall?
I do not. Thank you.
Ms. Hall, how do you wish to plead to the charge that on or about July 29 of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of police officer assaulting, resisting, or obstructing? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, they have not.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No.
Mr. Steen?
No, Your Honor.
Other than the no further upfront jail at the time of sentencing, has your attorney promised you any particular sentence or estimated what your sentence will be, Ms. Hall?
She has not, Your Honor.
All right, is it your own choice to plead guilty?
It is.
Ms. Hall, on July 29 of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
All right, and at that time, did you come in contact with an Adrian police officer? Is it Nieto or Nieto?
Nieto.
She pronounces it Nieto. Did you come in contact with a city of Adrian police officer named Rose Nieto?
Yes, in traffic, I did.
Okay, was she wearing a uniform?
Yes, she was.
Was she in a police car?
Yeah, and I was walking.
Okay, so you knew she was a police officer.
I did, Your Honor.
Okay, so tell me, did you assault or batter or wound or resist or obstruct or oppose or endanger Officer Nieto?
When she called my name from her vehicle, I went into a building that had like the Masonic temple. So you have to put a code in to get through the door. So I had the code. I went into the door. By the time she could get out of traffic and get to me, I had shut the door behind her. So yeah, I pretty much locked her out and didn't open it back up for her, knowing that she was trying to reach me.
So when you initially saw her, she was performing her duties and she asked you to stop. So you basically ran away and shut a door on her.
Yes, I did.
Okay, Mr. Steen?
People are satisfied, Judge. Thanks.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Steen?
Yes, Your Honor.
accept the plea it has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew plea regarding sentencing. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set sentencing for June 27 at 8:15 in the morning. Ms. Hall, you have the right to appear in person or via Zoom. How would you like to appear?
Either way is okay with me.
Zoom is all right? Okay.
Yeah.
All right. All right. So, Ms. Hall, someone will come talk to you. Just be truthful with them about your background, what's going on. They'll update your pre-sentence report and we'll see you back around that day. Thank you.
Thank you. Thank you. Have a good day.
You too. Thank you. All right. So, Ms. Underwood, let's get your next one in here. Trevor Austin. All right, Mr. Austin, if you could start your video and your audio for me. Thank you. This is in the matter of the people of the state of Michigan versus Trevor Austin. And this is file number 22-20788FH. I have Rhonda Underwood appearing on behalf of Mr. Austin. And this is a probation violation. So, Ms. Underwood, how would you like to proceed with Mr. Austin?
Your Honor, Mr. Austin did turn himself in on the OWI. That was outstanding. He has an arraignment scheduled for that. And so I would ask the court to set this out for a month or two, Your Honor, allowing that to take place. I don't believe the probation
22nd.
department is going to object to that.
Okay, Mr. Moore,
Yes.
is he in compliance right now with probation?
Yeah, so I was just on the phone with St. Joseph County and they're waiting for, did you say you had a court date, Trevor? For them?
Yeah, for the 22nd.
Okay, because they didn't have it. Okay, so that's for that OUIL, right?
Yeah.
Yep.
Okay. By the way, you're aware you have a warrant out in Jackson County from for a retail fraud. Did you know that?
That's from a long time ago. Yeah.
Yeah, for failure to appear or no. Not a
Okay, so
failure
Mr.
to-
Austin, you need to take care of that too, all right?
All right.
That was according to the warrant, it was during your probation period, so you got to clear these up.
There was that. What? Maybe it was. All
Okay,
right.
so I need you to go take care of that too. I'm going to adjourn this to August 6th at 8:30 in the morning.
Yeah.
Mr. Austin, don't get in any more trouble. Stay in compliance with
I'm
your
not getting
probation
any more
and
trouble.
take care of both these warrants.
Yeah.
So we will
Okay.
mail a notice of hearing out. So thank you, Mr. Austin.
Okay.
And make sure you keep in touch with Miss Underwood so she knows, you know, where you are in the process.
What was
And-
August what, Your Honor?
August 6th.
August 6th.
What is that
Okay.
date, Your Honor?
Thank you.
August 6th at 8:30 in the morning. All right, thanks,
Okay.
Mr. Austin. You're all set.
Thank you.
All right, Darius Bailey next, Miss Underwood. Well, let me call. Okay, good. Hey, this is Judge Anslow. We're ready again for Christina Edmonds.
Okay, I'll get her in.
Awesome, thank you. Bye. All right, Mr. Bailey, go ahead and unmute your device. This is in the matter of people of the state of Michigan versus Darius Lamar Bailey. All right, Mr. Bailey, if you're driving, you want to pull over for me? Over.
Ron, I'll do it for Mr. Bailey.
What? All right, Mr. Bailey, I need you to unmute your device.
Can you hear me now?
Yep, okay. This is in the matter of the people of the state of Michigan versus Darius Lamar Bailey, file number 20-20067FH. I have Rhonda Underwood appearing on behalf of Mr. Bailey. This is also, this must be Mr. Moore as well. So, yep, looks like Tom Moore. So, Ms. Underwood, I think we previously adjourned this to see what was going on in Battle Creek. And then, so we have the February 12th violation of probation, Mr. Moore. And then I think we also have the July 30th, 24 violation of probation. Is that correct?
That sounds about right. Here we have, I believe it was a flee and elude.
Mr. Moore, it's my understanding Mr. Bailey paid off everything yesterday. Is that correct?
That's correct. That's correct.
All right, so can we then maybe, hold on. Well, he paid off everything, but he also has, there were some charges out of Wayne County and charges out of Battle Creek. So those are all outstanding. So Ms. Underwood, how would you like to proceed today with Mr. Bailey?
Mr. Bailey, what's going on with the charges in Battle Creek?
I got court next month in June.
But yesterday you paid off some $9,000, correct?
Yes. I have court, Battle Creek, June.
Thank you, Your Honor.
Is all the stuff in Wayne County taken care of from last year?
I got to call Wayne County because I paid off Detroit. I don't know why they didn't take that off yet. I got to take care of Troy.
Well, there was a violation for driving with license suspended out of 36. So
yeah, I paid. I don't know why they didn't take that off. I paid them off. I don't know why that's still.
Well, it may be. I don't think that one. I think if you're talking about I think that would have been taken care of. I don't. You're just. I think Mr. Bailey saying he thought he'd take. I think that one's taken care of. I guess I just will give a brief, review here that originally it was a show cause for us because of the large amount of restitution. This case is for financial transaction. He's made restitution whole in this case. I realize he has that going on over in the other county. But in regards to this and our show cause, I would say that he's filled that obligation. So we can close that. So
do you want, are you at this point willing to revoke and terminate his probation?
I am, that's up to you, Your Honor. I have no issue with that because as far as this case is concerned, he's made whole.
Okay, so Mr. Bailey, I'm going to revoke and terminate your probation. You'll receive paperwork, so you will no longer be on probation with me. Just make sure you get out there and take care of that stuff in Battle Creek, all right?
Okay, thanks a lot.
All right, thank you, Mr. Bailey, for paying everything in full. You have a good day.
Thank you.
All right, Ms. Underwood, I've got, all right, so Ms. Edmonds will be with you in just a moment. Joshua Johnson, can you hear me?
Yes, ma'am. Yes, ma'am.
All right, so this is in the matter of the people of the state of Michigan versus Joshua Johnson. We have file number 25-22185. I have Rhonda Underwood appearing on behalf of Mr. Johnson, and I have Isaac Sneed appearing on behalf of the people. So, Ms. Underwood, how would you like to proceed today?
Your Honor, I've discussed this matter with Mr. Sneed and Mr. Johnson. I think I'm going to have one more talk with Mr. Johnson regarding possible outcomes, but I don't think that should be too long. And I also may be consulting the court on a Cobb's, but so I would think a quick pretrial, Your Honor.
Any objection, Mr. Sneed?
No, thank you.
So I can do June 11 at 8:30 in the morning. So Mr. Johnson, I'm going to set this over for June 11 at 8:30 in the morning.
And I'd be happy to do the stipend order.
Yep, Ms. Underwood's going to do a stipend order to adjourn. Mr. Johnson, you need to make sure that you zoom back in on that day. Mr. Johnson, are you still on Summit Street?
In Hillside, Michigan, yes, ma'am.
Okay, Mr. Johnson, you're going to receive in the mail an advice of rights form and a self-addressed stamped envelope. I'm going to need you to read the advice of rights form. Then I'm going to need you to sign it and date it and then fold it up and put it in the self-addressed stamped envelope we provide to you, and then go put it in a mailbox or at the post office, okay?
All right, is there any way I can just come to the courthouse and pick it up?
You know what? You are more than welcome. If you want to come in person to the next court date, you can do that.
Okay, well, either way, yes. All right.
All right.
Yep,
If you decide you want to come to the courthouse and pick that up, you can go to the clerk's office and my staff will have it brought up to you to sign. Otherwise, you can come in person the day of the next court date and we'll have you sign it then. All right?
Yes, ma'am. Thank you.
All right. Thank you, sir. You have a good day.
You too.
All right. Miss Edmonds, let me check one more thing, Miss Edmonds. So we did that one. That one. All right, so Ms. Underwood, I believe, in the matter of the people of the state of Michigan versus Kayla Walden, file number 25-22101FH. Ms. Underwood, this is a violation of probation pretrial. And I do have a proof of service showing that we ordered her to appear. I don't know if Ms. Underwood's been appointed on that one yet. So Ms. Walden was ordered to appear today. She's failed to do so. And I'm going to issue a bench warrant for her arrest. And I'm going to set bond.
She's in residential treatment at Dawn Farms. I have verified that.
So do you want me just to adjourn this out then?
Let's adjourn it out. Maybe another. She went there about a month ago, so let's adjourn it out 30 days.
How about June 18 at 8:30 in the morning?
That's fine.
What's the date again, Your Honor?
June 18 at 8:30 in the morning.
Thank you.
Okay, awesome. I'm glad to hear she's there. Wonderful. All right, so, and I just threw my pen at the wall. All right. So Ms. Edmonds, let me grab your file. All right, so Ms. Underwood, I arraigned Ms. Edmonds earlier. So Ms. Walsh, just because, are you there, Ms. Walsh? Okay, so Ms. Walsh, just because I was stumbling on it. So Ms. Edmonds has 4 violations of probation. The first one is that on May 1 of 24, she violated bond conditions by consuming alcohol. Is that bond conditions on this one or bond conditions on a new file?
Judge Olsaber put that on for this file. Instead of making her put on bond conditions for with Darren, he did it with us, so that would be cheaper for her.
Okay. Okay, so, I didn't do that, so Ms. Underwood, so I think I missed that. I didn't understand that. All right, and then the second allegation is she violated bond conditions by tampering with Scram. May 1, she consumed alcohol, and May 8th refused to enter residential as ordered by this court. So those are the 4 allegations against her. She requested court-appointed counsel. I'm gonna open up a breakout room. And Miss Edmonds, I'm going to put you and Miss Underwood into, where's Miss Underwood? Where's the jail? Go. All right, I'm gonna open up that breakout room. Go ahead and join that breakout room. You can if you want. There's like so many of them. All right. Yeah, you are more than welcome to take those, Becky. See, I told you to get done on time for the attorney swearing. Miss Teskey, the new prosecutor, Nicholas Sears, is being sworn in at 11:45 with Judge Olsaver. And he's the one that's
Okay.
involved in our recovery court.
Yep,
Maybe let Teresa know too.
I will.
But I think I'm done with you.
Are you?
I think so. The only thing I
Okay.
have left is this violation of probation.
Okay, sounds good. Thanks, Judge.
All right, thanks, Sarah.
Bye.
Oh, there you go. All right, let me close that breakout room. All right, so we're back with Miss Edmonds. Miss Underwood, how would you like to proceed?
Your Honor, all I've been given is a copy of the summons and warrant. I don't have copies of the orders that Miss Edmonds is alleged to have violated and when they were signed. Miss Edmonds really desires to get out of jail because she's scheduled at Catholic Charities in Monroe for an intake this afternoon at 1:30, Your Honor. I would hope the court might consider letting her out to do that.
So on May 7 of 25, I signed an order requiring her to enter and complete residential treatment. Judge Olsaver ordered, and an order was entered on April 22nd of 25 that she must comply with SCRAM and not use any other or use alcohol. So we will get you those orders. And so the allegation is that she violated those conditions by consuming alcohol and tampering with her SCRAM unit and refusing to enter residential treatment. So Ms. Walsh, can you verify that she's been admitted to Catholic Charities? That's not an inpatient program. You're muted, Ms. Walsh.
No, she was given the chance for residential treatment on Thursday, when she found out that we were aware of a positive alcohol. The alleged OWI comes only 8 days after her initial sentencing from you, Judge. So I have tremendous concerns for her getting out. She was on alcohol monitoring and we do have a positive test. She's denying and a tamper, which means that she put something between her leg and the bracelet to try to throw off the SCRAM. So I would ask that she does not get out of jail. We don't have another recourse at this point.
So Ms. Underwood?
Ms. Edmonds?
Yes.
You want to plead guilty to the allegations? I saw you shaking your head. Or do you want this set for a hearing?
Can we go on a breakout? Can I talk to her again?
Okay.
Yep.
Okay.
I'm going to reopen that breakout room.
Thank you, Your Honor.
Rhonda's back.
Let me close that breakout room, bring your client back. All right, so we're back on the record. Ms. Underwood, how would you like to proceed with Ms. Edmonds?
Your Honor, this is a pickup today. And here's what I would like, Your Honor, is does the court have some time, maybe Friday morning, so I can go over tomorrow, maybe, and see Ms. Edmonds at the jail, and we can talk face to face and.
Ms. Adams, do I have any available time at 8 a.m. on Friday or on Friday?
Judge,
I know I
Friday
have
is
5
really
sentencings Friday morning.
Don't you have like 10 sentencings Friday morning?
Yeah.
Friday late morning, Friday afternoon.
Morning's really bad. The afternoon you have a 1:30 evidentiary motion to change custody and nothing other than that in the afternoon.
About 1:30 on Friday, Ms. Underwood.
Thank you, Your Honor.
All right, so Miss, are you available then, Miss Walsh?
Yes.
All right, so I'll set this over to May 16 at 8:30 in the morning, or 1:30 in the afternoon, I mean. So May 16 at 1:30, I'll enter a plea of not guilty, and we will see you back at that time. Thank you, Miss Underwood. I do believe that concludes our criminal docket. Thank you.